Yeah, yeah, yeah. You ain't ready for this wave, you should get up on my way. God been blessing me too much, I better watch what I pray. I'm the child of a king, you better watch what you say. Ask the enemy what happened when he called me out my name. Yeah, yeah, yeah. Cause if you tryna talk to me, you better watch how you speak. I don't care who you running with, I'm on God's team. Got the light, future's bright. When I walk, bro, I gleam. Ain't know what I'm tryna be. This that you ain't never seen. This that I say what I mean. This that every verse is clean. This that wish somebody would. Cause I really like my seat. Ask the enemy what happened. He must really like my feet. God already got the dub. I don't see us getting beat. And I got the spirit with me. Now I'm strong. When I'm weak, you ain't ready for this wave. You should get up on my way. God been blessing me too much. I better
Everything husky.
Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes on. It takes some time to say goodnight. You close your eyes to dream next thing. Tomorrow's here again.
It's a brand new day, never hold on to hate. Cause you was placed here to be great. Please take your place. All queens got a seat at my table. Cause without y'all, then the man ain't able. Melanated queen, connected to the universe. And so I gotta thank my mom for my birth. If hate is the curse, then love is the remedy. So I send you love no matter creed or identity. Until infinity, look at you like you kin to me. Even when we disagree, yo, you still kin to me. In other words, I can't bring you no trouble, can't bring you no beef, don't wanna see you deceased. Now if I'm coming at you, I'm coming with a business plan. Cause every day I'm on some, yo, let's get this money, man. Yeah, and that's my real plans. I rest my head at night, I wake up, I got another plan.
Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes on. It takes some time to say goodnight. You close your eyes to dream next thing. Tomorrow's here again.
It's a lot of high rappers tell me why we don't get money together, but we'll kill each other over whatever. Running down the freeway, we gonna own down. If Black Lives Matter, why we gonna own down? That's why they laugh and they think that we clowns. They hear what we say, but see how we get down. We gotta change that now, right now to be exact. Cause hurting that man's moms is not where it's at now. Old school, new school need to learn, yo. They put us in groups so they can make more dough. The young versus the old versus the young. Black versus white, you see the pattern, right? No unity, keep them all on some gutter-ish. This way they don't prosper and get rich. Yo, can't you see it's a trick? Just open your third eye and you'll see the full view of it. Now yo, what if the powers that be know that the real power lies within the people? That's us. And what if they using things like crayon colors, black and white, to separate the people? Hey, yo, you gotta wake up. Don't let them fool y'all. Spread love.
Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes on. It takes some time to say goodnight. You close your eyes to dream next thing. Tomorrow's. Good morning, it's another day, my friend. But soon the sunshine turns to moonlight, life goes on. It takes some time to say goodnight. You close your eyes to dream next thing. Tomorrow's here again. Good morning, good morning, good morning, good morning. Good morning, good morning, good morning, good morning. Good morning.
All right, y'all know what time it is. You know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. We about to get into it. Appreciate everybody who's in here. It's gonna be a crazy show. Y'all get ready. Hold on 1 second. Let me share this live stream out so we can let everybody know that we're live, because this is going to be a great one, man. Shout out to everybody who's in the building. Y'all know what to do. I see some ones in the chat. We should be good. We should be good. All right, we're sharing out the video. I should have done this earlier, but y'all know I be up here slacking. I'll be up here slacking sometimes, man. All right, we're ready, man. We are ready. Let's go ahead and get into it. Turn the music down a little bit and see how we looking. Oh, all crispy and clean on the screen. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host, ClassE Beats of ClassEbeats.com. Today, we have some breaking news for y'all. It's getting wild. Today is that day. Today's that day. We're going to hear some responses. It's response day. And this is going to be a lot of fun. We've also got a very special guest for y'all. Y'all are really going to enjoy our guest today. Going to get some great insight when it comes to legal matters and some of the things that are going on in this trial. And if you guys have any questions, you can call in as well. But if y'all want to call in throughout the show as we're going throughout topics, the link to call in is in the description and also in the pinned comment in the chat. We're going to get into it here in a second. But first, y'all know I got to say what's up to the people, man. Who do we have in here? Javier LaFleur is up in here this morning. Shout out to Javier LaFleur saying what's up. I think Amy was the first one in here. Shout out to Amy showing love in the building. We've got Cheryl Balicki. Cheryl Balicki, I believe I said that right. She said, thanks for all the explaining. Hey, I'm just a guy with a little bit of common sense trying to break things down for you. We got Boss in the building. Shout out to Boss. Mixed Chick Samantha is up in here. We've got Kristen Vasquez, the birthday girl, is in the building. Happy belated birthday to Kristen. Good to see you here and thanks for stopping by. Who else is in the building? I know I missed somebody. Dang, we've got El Papicito says, what's poppin'? Let's go. Brand new whip just hopped in. Y'all know what it is. We got Satins in the building, says greeting everybody. Greetings everybody and grand rising. Beth Davis is in the building and said, I can't stand Miss Love. Dang. Straight in with the smoke. I see it. Well, we're going to talk about Miss Love here in a minute because it's going to be a lot of fun. We've got Jean. Is it French? I think that's French. We've got Jean Lee. I think that's Amy's cousin over there. Says good morning. Good to see you in here. All right. If y'all are ready, we need to go ahead and get right into it because we've got a lot to cover today. Y'all see the title of the video. The defense is not backing down. They heard what the state said. They were trying to quiet them. They were trying to get a gag order out here. And the state said, oh, we're not doing that. There's no way y'all are going to stop us from talking. But we'll get into all that here in a second. Before we do, let's go ahead and give a couple of announcements. Y'all know what time it is. Oh, that is the wrong one. Dang. I'm on the wrong screen. There we go. Tonight, 8 p.m. Eastern Standard Time, we've got another episode of the Song of the Night Live. We're going to be giving away $100 in cash and a brand new Shure 55SH microphone. So if y'all want an opportunity to hear some great music, if you're an artist, you want to get your music heard, get to meet some great people that you can collaborate with and get an opportunity to win, make sure you tune in tonight. Tonight is special as well because we are giving away 4 door prizes and 2 spots in next week's Versus Challenge. All right. So the winner of tonight's show is going to get a spot in the Versus Challenge, and then we'll be randomly selecting one artist who gets played during the show to get a spot in the Versus as well. So it's going to be a lot of fun. If y'all haven't checked out the show, just stop by, say what's up. We'll show you some love in the chat. It'll be a good time. Who else we got in here? I want to say what's up to a couple more people, and then we'll get right into our breaking news. Chainsaw P is in the building. He says, Buenos dias. Buenos dias. Good to see you, man. Did I miss anybody else? I don't think I did. I shared out the video. Y'all know we got the state in here watching. We talked about that the other day. And they let us know. They let us know in this last motion they filed. They said, hey, we're watching y'all. So be careful. So shout out to the state. I appreciate y'all watching. Y'all can like the video too. I've been showing y'all some love. I know we've taken a couple of shots, but y'all can like the video. It's free. I don't think it's going to affect the trial if the state likes the video. So y'all take some time, like the video. Not only does it help the show continue to grow, but it lets the algorithm know that you guys are enjoying the show, or if you're the state, that you're getting all the information you need for this trial. So make sure you like the video, help us to grow. It helps the algorithm and it lets more people know about the channel and about the show as well. We've got Wisen You Poet. I know I'm saying that wrong. They say blessings in there. We got to get into it. It's time, y'all. It's time for the breaking news, and y'all are gonna love this one. Y'all are gonna love this, I promise. This is crazy. This is absolutely insane. And I need to... I'll give y'all a little background here in a second. All right, here we go. So, as we knew was going to happen, once we had the prosecution go and file basically a gag order saying that they didn't want attorneys out here talking about the YSL RICO trial, what was going on with the trial, what their feelings were. Miss Love said, hey, I don't want anybody over here throwing shots, talking about my attitude. Well, the defense responded, and we're going to get into it here. This is breaking news. If y'all haven't seen what I'm talking about with the extrajudicial motion, you can go back and watch that video where we pretty much break it down and explain everything that's said in here. But right here, we have Doug Weinstein, aka DeMonte Kendrick's representation, aka Yak Gotti's representation. He responded to this motion that was filed by the state. What is he saying here? Kendrick's, well, we'll start it off the right way. The state of Georgia versus DeMonte Kendrick. Right, here we go. Kendrick's opposition to state's motion to restrict extrajudicial statements. Basically, they're trying to shut it down. They don't want them talking. Here's what he says. Comes now defendant Yak Gotti, we're going to call him, in the above style case in opposition to the state's motion to restrict extrajudicial statements. I'm going to get it right one of these days, y'all. Showing the court the following. Everyone is in favor of free speech. Hardly a day passes without its being extolled. I agree. But some people's idea of this is that they are free to say what they like, but if anyone says anything back, this is an outrage. Sir Winston Churchill. That's an excellent quote by Mr. Weinstein there. I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not going to target anyone. You do not get to commit crimes in my country and then get to decide to brag on it. Which you do that for a form of intimidation and to further gain and to not be held responsible. The Honorable
Stop the cap.
Fannie Willis, Fulton County District Attorney, press conference, August 29th, 2022. Now, why is he quoting this? Because the top of the top of the top, which I mentioned when we were on the live stream Wednesday, when we were on the live stream Wednesday and in past videos, that this is completely hypocritical by the district attorney's office. For them to say they don't want anybody talking about it, and then you had Fannie Willis, while she was involved in an active case, an active trial, an open investigation, whatever you want to call it, speaking out about it on multiple occasions, which we're going to show evidence and proof of here. This is an excellent quote and an excellent call out, because Fannie Willis was going all over the place doing exactly what they're trying to stop these attorneys from doing. You can't do that. This whole thing is a bunch of BS, but hey, Mr. Weinstein is going to keep going in. Free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. This should not be surprising to anyone that has paid attention to the present case over the last 19 months of trial. Oh, man, Weinstein is letting them fly. Shout out to Yak Gotti. The state would apparently like the present trial to be conducted in secret, with proceedings happening in hidden chambers outside of the prying eyes of the press and the public. God dang. Yo, I'm going to be going crazy with the sound effects on this one, because Yak Gotti's his representation were cooking on this. This is crazy. So not only is he taking shots at Fannie Willis, not only is he taking shots at Judge Glanville, who pretty much botched this entire trial from the start, but he's taking shots at the ex parte meeting that took place at ADA Love, ADA Hilton. He's burning all the bridges here. He did call Fannie Willis honorable, which I'm not.
Stop the cap.
I'm not going to do that. She stole my money, so I'm not rocking with Fannie right now. But let's go back. Let's keep reading. So he says, the state has repeatedly sought the secreting of witnesses' identities, even in instances where the state has made no showing of risk to the witness, despite the court's order that such a showing be demonstrated prior to blocking the broadcasting of witness testimony. Exactly right. After attacking the integrity of representative counsels of defendants and witnesses, they're referring to Brian Steele. When he went back with Judge Glanville said, hey, you're unprofessional and unprepared. And as we saw, Brian Steele had a big issue with that. And he goes into more detail here. Repeatedly calling the Honorable Brian Steele, there we go. See, it's not just me. The Honorable Brian Steele a liar, and accusing the Honorable Jonathan Melnick of working for the defendants rather than his client, Lil Woody. The state now turns its attention to counsel for DeMonte Kendrick. Mr. Weinstein is taking this personally, as he should. But to paraphrase President Truman, counsel does not give the state hell. Counsel tells the truth about them, and they think it's hell. In a 1.5 page motion, the state cites the Rule 3.6 of the Georgia Rules of Professional Conduct and cherry picks certain comments to the rule to support its motion to instruct the defense to refrain from making extrajudicial statements about the case moving forward. No case law is cited. No finely tuned order is proposed. As the state accurately quotes 3.6 bars, excuse me, 3.6 bars lawyers for making extrajudicial statements that a lawyer knows or reasonably should know have a substantial likelihood of materially prejudicing an adjunctive proceeding in the matter. The state provides no specific quotes of Kendrick's counsel that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt among 208 minutes of interviews to find statements by Kendrick's counsel that might arguably violate Rule 3.6. Oh man, Weinstein is cooking. And we're going to get to 3.6 here in a second, but I've got some other things I want to show y'all. The court should decline this invitation. Remarkably, the state does not make a single argument that any statement by Kendrick's counsel meet any of the elements of Rule 3.6. Instead, the state simply offers up a single conclusionary statement. There is no argument that any statement made by which is being streamed daily to the public. To the extent there are any remarks not specifically in the public record, such statements are general remarks indeed to demonstrate that Kendrick should not be on trial. And I mentioned this too. I didn't have a problem with them talking about the case. What I had an issue with was the risk of them saying that something that's not known to the public, or something that's attorney-client privilege. And I just said it was risky and I didn't think it was worth the risk. And that's basically what Mr. Weinstein said here. He said, yeah, maybe we were talking about the trial, but we weren't talking about anything that no one else knows, which is totally allowed by 3.6. Justice Kennedy rightfully understood the present situation that Kendrick and his counsel find themselves in. Kennedy wrote that an attorney's duties do not begin inside the courtroom. He or she cannot ignore the particular implications of a legal proceeding for the client. An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of indictment, especially in the face of a prosecution deemed unjust or commenced with improper motives, which we have seen over and over. I mean, they got Judge Glanville out of there because, as Brian Steele said, he was on their team. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. Okay. And then he cites a few more things. We're not going to go through all that. But he says, this is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who is an artist. He writes, records, and performs rap music and lyrics. In Fulton County, this makes Kendrick a target of the state. Kendrick is allowed to take reasonable steps to protect his reputation, and those steps may be taken by his counsel rather than through a public relations firm. Having smeared Kendrick and his reputation, the state wants to silence him, initially by placing a burden on his free speech rights to write about the world in which he lives and the tragedies and injustices around him. And now by holding press conferences denouncing him and his writing, while subsequently seeking to bar him from defending himself in the court of public opinion. Wow, I'm so glad he brought up the court of public opinion, because we've mentioned it several times here. We're all able to see everything that's going on. We're able to see Glanville. We're able to see Brian Still. We're able to hear the witnesses and see Lil Woody on the stand have an attitude with Miss Love up there. So we're able to see all this. The court of public opinion is very involved. And moving forward, that's something that you're going to have to factor in as well, and something that even factored in to Judge Glanville being removed. So that's a great point by him. While the state has unfortunately been successful in impermissibly burdening the free speech of Kendrick by limiting his present and future writing, the state should not be allowed to bar him from defending his reputation. Wherefore, Kendrick prays that the court deny the state's motion. Respectfully submitted, Doug S. Weinstein. Give it up. Give it up to Mr. Weinstein. That man went in on this one. This is probably going to be one of my favorite motions so far, because he did not hold back, and he even pointed to ADA Love and ADA Hilton's boss to say, your boss was out here talking when she shouldn't have been, which we're going to get into actually in a second. I want to go to 3.6 in case y'all hadn't seen this yet. And sorry, it's not centered on the screen. Let me get this for y'all so I can center it on the screen. There we go. All right. Rule 3.6, trial publicity. We're going to go through it real quick. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing and proceedings in the matter. All right. Notwithstanding paragraph, a lawyer may state the claim, offense, and defense involved and expected when prohibited by law, the identity of the persons involved, information containing in public record, which they're talking about. Everything they're talking about in these interviews is public record. And we've actually seen on video in some cases, right? That an investigation of the matter is in progress, the scheduling the result of any step in litigation, a request for assistance and obtain evidence and information necessary thereto, a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. In the criminal case, in addition to subparagraphs 1 through 6, the identity, residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in apprehension of that person, the fact, time, and place of the arrest, and the identity of investigating and asserting officers or agencies and the length of the investigation. Notwithstanding paragraph A, a lawyer may make a statement that is reasonable. This is important right here. A lawyer may make a statement that a reasonable lawyer would believe is required to protect the client from the substantial undue prejudice effects of recent publicity not initiated by the lawyer or the lawyer's client. AKA Judge Glanville being kicked off the case. I mean, you could argue this so many ways. A statement made pursuant to this paragraph shall be limited to such information as it is necessary to migrate the recent adverse publicity. No lawyer associated in a firm or government agency with a lawyer subject to paragraph A shall make a statement prohibited by paragraph A. All right, so that is 3.6. We got to look at this video so y'all can see and let me know, because Fondy Willis, the DA, she was making statements while everything was going on with the trial. We'll see if y'all think they were included in that or not. Let me unmute this and then we'll run it. Hold on a second.
Less than 24 hours after filing a motion to dismiss an appeal that could remove her from prosecuting the election interference case against former President Donald Trump and his allies, Fulton County District Attorney Fondy Willis spoke about the challenges she faces in her position.
And while she did not address the case directly, Willis did address her critics at a church conference in Marietta. Here's 11 Alive's Karis Belger.
Fulton County District Attorney Fondy Willis took the opportunity to talk about judicial equity and take shots at her critics during a speaking engagement at Turner Chapel AME Church. Willis did not talk specifically about the appeal, but she did reference former President Donald Trump and his supporters like Rudolph Giuliani, stating her goal has always been to hold everyone who breaks the law accountable, regardless of their status.
She said, what?
She also used biblical metaphors, specifically citing the Old Testament of the Bible, to explain not only her focus on continuing her work, but the support she's received from those in the religious community, like Bishop Ronald T. Jackson, who introduced her at the event.
What stood out to me is that God will team up a civic leader with a religious leader to fulfill his purpose.
This disgusts me to this day.
Civil servant Nehemiah, he put around him a prayer warrior, Ezra.
Willis is attempting to block the Court of Appeals from hearing arguments to disqualify her from prosecuting former President Trump and his co-defendants. If her appeal is denied, the court could hear arguments in October. I'll have more on her remarks on 11 Alive News at 5.
All right, shout out to 11 Alive. So apparently, Fondy Willis could go and talk to a church and have a whole press conference and say something about Trump and Trump supporters, but we can't have interviews with these lawyers, man. They need to get out of here. If what I've seen from Judge Whitaker is true and is going to stand firm in most of these cases, she's not gonna listen to what the state is saying on this one. And they're clearly just don't like what's being said, and like it or not, they have a right. You have a right to free speech. You have a right to speak on this. Even if you go back to Rule 3.6, you have a right. They have a right to talk about their client and what's going on with this trial. And we're watching it before our own eyes as well. So y'all let me know what you think. This was a great response from Yak Gotti, aka Doug Weinstein. But is it going to be enough for Judge Whitaker to say the state needs to go sit down? Let me see what y'all are saying in the comments, and then of course in the live chat as well. So I stopped the wrong thing. We're gonna get into here. Let me see what y'all are saying. Shout out to everybody who's in here. Javi said I need to check my phone. Oh, okay. So we'll bring him up here for a minute. I got you. So I'll read y'all's comments here in just a second. I want to bring our guest up here because he's got to go in a minute. So let me see if I can get him in here. Make sure we're all good. Oh yeah, I can hear him in there. Y'all give it up in the chat for the man, the myth, the legend. Not really the myth. We know he's here. Javier and Bailey the third is up in the building. Yeah, sorry Javier, I didn't mean to take that long. I was over there cooking, man. I took too long on you. But I appreciate you stopping by, man. Good morning.
Morning, man. Morning.
All right.
How's everybody doing?
So the chat is saying what's up to you. They're happy to see you in here. Y'all give it up and show some love to Javi in the chat. Amy's over there clapping. She said, "What's up, Javi?" So
What's up, Amy?
I know you don't have a lot of time, so we probably won't get too many of y'all up here. If y'all have any questions, make sure you type them in the chat. If you want to call in real quick, you can do that. But were you able to hear this response that was sent by Yak Gotti's representation? And if so, what do you think about this response that we just heard?
I think I think the response is the motion is very much on point and accurate. I think the only reason why the state is even filing their motion to restrict extrajudicial statements is because they no longer have, I think, their favorite judge, Judge Glanville, on the case.
Talk about
If
it.
yeah, if I guarantee if Judge Glanville was still on the case, we would have never gotten that motion from the state telling everybody to stop talking, and we don't want to, we don't want to hear any more outside of court statements about this.
Yeah.
I think it's just all because they lost Judge Glanville, if I'm being honest. But as far as the motion in response to that, it's on point. I think that when you look at 3.6, this is public. It is public record. It's something being streamed. Not only is it public record, but it's being streamed to the public every day. And I saw a couple of those exceptions that allowed them to make those statements and to speak about it. And one last thing, the only thing I saw them really commenting on is the recusal of Judge Glanville. I really didn't see them saying anything just, out of the ordinary.
Right. Exactly.
Yeah.
Yeah. And I mean, well, first of all, shout out to Roro said, I didn't even introduce Javier properly. Javier M. Bailey III is our resident attorney here. Shout out to him. I'm gonna let you introduce yourself a little bit and tell the people what you got going on, man. I apologize.
Oh man, no problem, man. I'm Javier. The music community knows me as Javier LaFleur. So you may see me, if you see me in the chat, that's me.
Yeah.
Also, I'm a lawyer. I've been a lawyer for 2 years. I do criminal defense here in Memphis, Tennessee. Man, I love it, man. I love what I do. It's just exciting. Just
Yes,
real exciting, man. No complaints.
And we appreciate your time too. Now I know you got to get out of here shortly. So
I do.
When it comes to, I guess, everything we've seen so far in this case, whether it be some of the motions that were filed over the past few days, the response by the state, even, what do you think is going to be the next course of action for Judge Whitaker? Or what do you see happening over the next few days?
Well, right now we're in. You're gonna over the next few days. Now that you've got motions filed, they're getting responses, even responses from the defense to the state's motion, state motions, response from the defense to response from the state to the defense motions. Also, right now it's motion time. That's what time it is. It's motion time. We're gonna see a lot of hearings on these motions. You're gonna see a lot of the former motions that were previously filed by the state, not by the state, by the defense, come back around. Motions for bond, motions for mistrial. That's why you see, I think it was Brian Steele who filed that motion to challenge the findings, the factual findings of Judge Krause.
Yep.
The reason why he's challenging that and doing that is because he's trying to lay down groundwork, or groundwork, for lack of better terms. He's trying to lay down the groundwork for a mistrial.
I knew it, man. I mentioned it as a chess move.
It is because you got Judge Krause, who I don't know if her and Judge Glanville are friends or not, but she came to the right conclusion, but with the wrong reasoning. She's like, Judge Glanville didn't do anything wrong. He's been, he's been presiding over this case fairly and ruling fairly, but the outcome of this case and what's been going on is giving the public the opinion or the view that the court is impartial,
right,
or is not impartial, is unbiased. So so that's the chess move with Brian Steele. He's trying to fix that, and probably gonna have this new judge rule on that to see if that was proper, so that he can lay down the groundwork so he can have a stronger case for a mistrial.
Now, say that with him laying this groundwork, we move forward and Judge Whitaker agrees with him, would that be a pretty big blow against the prosecution and extra points towards the mistrial, you think?
Oh yeah. Oh yeah. Yeah, it would. And if let's say the judge does grant a mistrial, I'm expecting this judge to grant these defendants bond.
Yeah.
I'm eager to see just by the circumstances of the case and what's been going on. I'm anticipating it probably be a substantial high bond, but I'm anticipating she's going to grant them a monetary bond. Um, Now, if let's say, is her name the new judge? Is that Judge Whitaker?
Yeah, Paige Whitaker. Paige
Whitaker.
Reese Whitaker. Mm-hmm.
Okay, Judge Whitaker. I haven't seen her too much, so I can't really pick up a pattern on how she's ruled on things. I guess we're gonna find out pretty. Um, I guess we'll find out pretty soon.
Yeah.
But let's say she does grant a mistrial. The state will have time. It's not just the end all be all of the case. It'll end there, but the state will have the option of whether they want to file a motion for new trial or to do this all over again. If
Yeah.
I had to guess, I don't think they would. It's been a lot of money and
No.
manpower, and it's just been too many resources.
Yeah.
But we'll see. It's interesting. This whole thing is interesting. But hopefully this judge is able to smooth a lot of this out and go forward a lot more easier than Judge Glanville was.
Yeah, absolutely, man. Well, hey, I
Yeah.
appreciate you. I know you got to go out there and you got to do your job and defend your
Yeah,
people.
man.
So I appreciate you, brother.
Man, my clients, Mr. Bailey, where you at?
Yeah, we gotta go run across the street. I appreciate you, man.
Yeah.
Well, hey, let the
right.
people know where they can find you, especially where they can check out your music. I know they'll see you over on the show here, but go ahead and say your goodbyes, and I'll let you get out of here.
Man, I'll see y'all later, y'all. I'm always here in the community. And something about me is with the music is I like to debut a lot of songs on this community. Like
Yeah.
if you tune into the morning show, a lot of people hear my songs first before I put them out, release them anywhere, YouTube or some of the music apps or anything. So yeah, I'm easy to find, y'all. Easy Google, Facebook, IG, or you can find me here, y'all.
All right.
But I appreciate the time.
Yeah, thank you so much, man. I know your time's valuable. Go do your thing out there saving lives. Y'all give it up in the chat for Javier M. Bailey III, aka Javier LaFleur. Salute to you, brother. Take it easy. I appreciate you.
Thank you.
All
All
right,
right,
peace.
man. I'll see y'all later.
Peace. Always good to hear from a professional, man. And Javier LaFleur is definitely one of those. So thank you for stopping by, man. Always a good time. And we'll have to get him up here a little bit earlier next time so he can answer some of y'all's questions and maybe give you a little bit more insight into what goes on behind the scenes with these legal documents, with the motions, with the proceedings and all that. And he's been on the channel a couple of times before. So now that y'all who are new to the channel have seen his face, go back and check out some of the videos on the channel that he was on. He gave some great feedback and insight into just legal proceedings in general. All right. Y'all are saying thank you to Javi in the building. Yeah, appreciate you. That was dope. Always good for him. Always good to have him stop by. So I want to check some updates and see if we have any more breaking news. And I should have. I'm ashamed of myself that I didn't do this, but the information I just showed y'all on that last reaction we just did, this is all from Thugger Daily. So I got to give it up to Thugger Daily. And now it looks like the full document is here as well. We've also got a couple other things we're going to go through. It's looking like the state has officially responded to some of the motions that were filed as well. I want to wait and see if I can get some of these full documents though. We've got Joseph Papp is talking about some of them. I know Thugger Daily is talking about a couple of them too. I'm going to see if I can find the full things, but yeah, Doug Weinstein was going in on the prosecution in that last opposition. It's crazy. Lauren Robinson said there's motions from Love and Weinstein. Yep, we're going to get into those here in a second. Let me see what y'all are saying about that last one we just read. Beth Davis says Fannie needs to pay you back your money. Yeah, that's what I want. How about that? Oh man. And shout out to Amy. She says, please like this video. Appreciate y'all. Definitely do it. We've got Tamoris Mickles is up in here. Salute. Appreciate you stopping by. Who else is in here? Who else we got? El Papacito says, says Trump's lawyers mentioned that same thing about Fanny's speech in Big Bethel, and Judge McAfee mentioned it in his ruling. And y'all want to know why? There's been so many missteps. Man, so many missteps by this district attorney's office, especially if you go and look back at how Fanny handled that entire Trump situation. It was just bad with some of the things that she was saying, some of the things that she was doing. And they kind of shot themselves in the foot there. Kristen Vasquez says, don't they have work to do? Stop trying to use the public works and truth to try and prove your case. Yeah. And they're watching right now. I know Kayla said that before too. They are watching. Mixed Chick Samantha says Kat Knott Williams is live. She might have them. Oh, okay. Shout out to Kat Knott Williams. Yeah. Y'all go check her out. She does a great job covering this as well. I'm going to try and see if I could find these real quick. Okay. Yep. I got him. Shout out to Thugger Daily. Thugger Daily's got him. So we're going to go through these motions too. We got a lot of motions today. Oh my gosh. Oh my gosh. We got 4 of these things. So we need to go ahead and get into them. This is going to be interesting. So we'll get this one. Yeah, I'm going to pull all these up, y'all. Y'all give me 1 second. Let me get some music for y'all and we'll go over these motions. We got some breaking news up in here. I was gonna go, so we were gonna do this another way, but shout out to Thugger Daily. Going crazy, man. Take a look at myself. And y'all also give it up to the Bishop, man, for being the soundtrack to the Music Morning Show. Okay, so Thugger Daily is putting us up on game. We have a bunch of these motions, or I should say responses that were filed. I think they're pretty much, they're motions. We'll call them motions. But anyway, we're going to go through these. We've got 4 of them we're going to get to. So we're going to take them one by one and see exactly what they're saying. I got to shout out Thugger Daily because I did not do it earlier. Let me see. Let me find it and then we'll go ahead and get into this first one. So this first one is going to be the state's response in opposition to defendant's motion for correct ruling on assuming facts not in evidence. Ooh. Yeah, we're going to need a little bit of background on that one. So let me see what y'all are saying in the chat and then we'll get into it. Let's go here. And let me make sure y'all can see these okay too. All right, just off a little bit. Boom. Got him. All right, chat. What are y'all talking about in the chat? Lauren Robinson says Sylvia too. Okay, so yeah, shout out to Sylvia and Kat Knott Williams. Y'all go check him out and show him some love. Amy said I need to get some water. Got it. Kristen Vasquez is up out of here. Thank you for stopping by, Kristen. Appreciate you. Weinstein stood on business. Yeah, he did. All right, we're going to go ahead and get into it. So I got to give props and shout out Thugger Daily. What does Thugger Daily say? Lots of responses from the state and, oh, hold on. Let me do this real quick. We got to start it this way. We've got over 1,000 likes. God dang. The state, listen, thank y'all, man. Thank y'all for liking the video. I appreciate it. Wow, we have over 1,000 likes. Sheesh. I didn't even have to go on and preach my whole sermon about y'all liking the video. Okay, so Thugger Daily just dropped a bomb. What does Thugger Daily say? Lots of responses from the state and some from the defense will be coming in today. First up, the state responded to Steele's motion to revisit the rules of evidence and for correct rulings on objections in 4 separate responses. So we got a lot to get to. So let's go ahead and get into this first one without delay. And again, all these came from Thugger Daily. Y'all go check Thugger Daily out over on X. This is Young Thug, aka Jeffrey Williams, aka represented by Brian Steele, versus the state of Georgia. This is a letter to Judge Whitaker. Here we go. And this is the state's response in opposition to defendant's motion for correct ruling on assuming facts not in evidence. Here's the intro. On June 10th, 2024, Young Thug moved this court to vacate proper rulings on state objections precluding cross-examination questions which assume facts not in evidence. Okay, let's read this note so we can get a little bit of background. On July 10th, 2024, Young Thug filed an amended motion. Young Thug's motion addresses multiple separate evidentiary rulings. The motion addresses paragraphs 10 regarding state's objections to assuming facts not in evidence. All right, defendant Young Thug does not include a request for specific relief or provide authority to substantiate his request. Instead, Young Thug critically asserts somehow his right to effective cross-examination has been curtailed. Dang. Trial court correctly sustained state's objection to question assuming facts not in evidence. Young Thug's motion should be denied. Okay, argument and citation of authority. We're actually going to get some cases here, so this will be good. At the outset, Williams never provides authority that inquiring into unproven and irrelevant areas, to wit, facts not in evidence, classifies as specific mode of cross-examination imparted by constitutional requirement. Okay, and we're going to see Johnson versus State. Even grounds that are constitutionally protected, however, may be subject to judicial controls. The right to acquire into partiality and bias, however, is not without limits. The Fifth Circuit has made it clear that questions which assume facts not in evidence are constitutionally protected and subject to exclusion by trial courts pursuant to the rules of evidence. Okay, that makes sense here. And then they say the rule permits court to precluding questions that obscure truth because there are ambiguous, confusing, misleading, argumentative, compound, or assume facts not in evidence. Well, if we look at how this trial's been going, I'm sorry, y'all, but you're not getting the benefit of the doubt, prosecution. I can see what you're saying. I'm not sure specifically what Brian Steele was trying to get changed here. Hopefully they'll give us a little bit more background, but we have no faith in you guys. I'm sorry. Young Thug's motion attempts to constitutionalize areas of cross-examination that is not so protected, even assuming arguendo, is that Spanish? That questions assuming, I don't know what that means. That questions assuming facts not in evidence were of the same stripe as an area like bias. Rules 401 and 403 and 611 would preclude Young Thug's proposed inquiries. All right. Williams' Sixth Amendment rights to effect cross-examination was not infringed by disallowing questions seeking to elicit facts not in evidence. Pursuant to both 24.1.103 and 24.6.611, the trial court has correctly prohibited Young Thug from posing questions that assume facts not in evidence. That's an interesting statement there. Well, we'll keep it moving. We've got 24.1.103 holds that the jury proceedings shall be conducted to the extent practicable so as to prevent inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof of asking questions in the hearing of the jury. Courts are mandated by 24.611 to exercise reasonable control over the mode and ordering of interrogating witnesses and presenting of evidence. Except for when it comes to Lil Woody. 'Cause we're just throwing all that out the window. But anyway, in order to make the interrogation and presentation of effective for the ascertainment of the truth, make the interrogation and presentation effective for the ascertainment of the truth. Reading these statements in conjunction with one another, courts are authorized to present counsel from asking questions in the hearing of the jury that are premised on inadmissible evidence to facilitate assertment of the truth. Young Thug asserts that the court's sustainment of objections for questions that assume facts not in evidence curtails his Sixth Amendment constitutional right, but cites no legal authority for that proposition. We kind of heard this in Weinstein's last opposition that he filed, basically saying that Brian Steele didn't cite any legal issues when it comes to, when it comes to this evidence. Case law explains that the Sixth Amendment provides two types of protection. Okay, we're going to skip through that. He also had objections to assuming facts not in evidence are proper. Permitting questions that assume facts not in evidence to a witness can confuse the jury because they are considering information that is never properly admitted as evidence in trial. Okay, you can see United States versus Almanzar. The court overturned a trial judge's decision to set aside a jury verdict based on insufficiency of the evidence because of the district court. And they assumed facts not in evidence and made unsupported assumptions. Young Thug's improper questions, which assume facts not in evidence, could confuse the jury deliberating, similar to the trial judge in Almanzar. Yeah, I wish they would point to exactly where this happened, because they're just saying, oh, he did it. And I would like to know where he said it, but I guess that doesn't have to be included here. Young Thug classifies such objections as specious, but the Supreme Court of Georgia and federal courts view them as unequivocally valid. Moreover, Young Thug seeks to ask questions that imply matters at best Young Thug cannot substantiate. For example, okay, here we go. Young Thug asked Deputy Belknap, do you realize that in Fulton County and in our country, the only artist lyrics that have ever been prosecuted in a criminal case are rap lyrics? Okay, so she's saying, I guess they're saying that that's not necessarily true. And we'll go to 11, watch live. Young Thug, YSL RICO trial, Georgia versus YouTube. Okay, and they actually referenced the video. Let's see if we can find this. This is super helpful. They're actually doing their job in this one. So we're going to go to the 6:12 mark. Let's see what Brian Steele was talking about. There we go.
All right. Were you aware, and I'm focused on the SMM or SMM or sex, money, murder, any of those words, and Pistol Pete or Two Guns Up, Pistol Pete, okay?
Yes.
Were you aware that prior to 2012, and I'll just say April 2012, there were other artists, musical artists, who used sex, money, murder, SMM, SMM in their lyrics?
Yes.
Were you aware before April 2012 that there were other artists, known artists, who used Two Guns Up, Pistol Pete, Two Guns, something that, using those words in their lyrics?
I don't know specifically those lyrics, no.
Okay. You ever hear of Rocco?
I have.
Okay. Were you aware of his song You Gangster Right?
I don't know that song.
Lyrics, oh, you don't know the song at all?
No, sir.
All right. You aware of Nas, N-A-S?
I'm sorry?
Nas, N-A-S?
Yes.
2002, Brooklyn, New York, the song Get Down?
I know of it, yes.
Okay, music.
All right, so basically he's got him on the stand going back and forth, and then we're going to fast forward to the point to where the state has an issue with. Here we go.
Do you realize that in Fulton County and in our country, the only artist lyrics that have ever been prosecuted in a criminal case is rap lyrics?
Objection, speculation.
I stay in the question. Do you realize that?
Objection.
Stay in the question, Mr. Steele. Come on, Mr. Steele, let's move on. Do you have...
Brian still said, come on, man. Let me have this one, Judge. So yeah, they wouldn't let him have that. That's the point where they're talking about. Okay, so let's keep moving through that. I mean, I can see what they're saying there. To begin with, this question is predicated on a falsehood as this court's detailed order on the introduction of gang lyrics proves this is not a true threat case. And not one defendant is being prosecuted for expressive activity of any kind. Okay, and they go to Exhibit A, which is 12. Chief Judge Glanville order granting admission of evidence of lyrics at trial, November 27, 2023. And this is, a lot of people had a big issue with the lyrics being used. And we've had this conversation and talked about it before, especially when this whole RICO case went down, because there's so many people, as y'all are even talking about in the chat, that have gotten in trouble for lyrics and some of the things that they said in their lyrics. And there's people who have even been caught up and gotten arrested and are in jail because of things that they said in their music. So yeah, they're being used and they're putting them in there. And thank y'all for the super chats. I'll be reading those here in a second. So Chief Judge Glanville, all right, he ordered it, found no defendant in the in-state case is being prosecuted for a charge involving a true threat or any exercise of any right protected by the First Amendment. Furthermore, the court finds that in neither briefing nor argument did any defendant demonstrate to the contrary, the emphasis was added intentionally. It should be noted that no defendant or group on their belief filed any motions challenging the legal analysis in this court's order on the admissibility of gang lyrics. Is that true? How did they not challenge it? It should be noted that no defendant or group on their behalf filed any motions challenging the legal analysis in this court's order on the admissibility of gang lyric evidence, much less sought a certificate of immediate review related to the same. I really find that surprising. Maybe it's just not that big of an issue, and it's something that they could easily deal with at court. But if that's the case, why wouldn't they try and, I don't know. We'll have to look into that a little bit more. Plus, the line questioning is unsourced and in conflict with known proof. No evidence had been introduced regarding national prosecution statistics on defendants' lyrics in criminal trials. The question also assumes that only rap lyrics have been prosecuted and thus is permitted on evidence never admitted at trial, a point that was refuted in the state's briefing and hearing on the admissibility of gang lyrics and evidence. Okay, so they're basically going to go back and forth through this. We'll get to the conclusion, and then we'll move to the next one. Young Thug's assertion that his Sixth Amendment right have been curtailed by the court's sustainment of the state's objections to question that assume facts not in evidence is invalid and unsustainable. There's no constitutional or statutory right to ask irrelevant and supported questions during cross-examination. The prior evidentiary rulings on this matter have been in accord with the Georgia and federal constitutions and rules of evidence. Young Thug's motion should therefore be denied. Respectfully, Adrian Love. All right. So what do y'all think, man? There's still a lot of background we have to give, but we got to see it in real time, what actually happened, a little bit of the line of questioning from Brian Steele. In this instance, I can kind of see what she's saying, but I think there may be more to it, and we'll have to see what Judge Whitaker says on this. All right, we got a super chat up in here. Oh my gosh, look at my guy Brock in the building. He says, support my guy. I appreciate you for the 2 bomb. Thank you so much, man. Oh, it's a 5 bomb. Let me put some respect on your name. Shout out to Brock for the 5 bomb. And thank y'all for the super chat and for supporting. You don't have to do it. I don't ask for it, but it's definitely is appreciated. I will be calling it out if y'all send super chats throughout the show. So thank you. Also, we've got Tracy in here. She says, hi, shout out to Tracy. Appreciate you stopping by. What does Lauren say? He said she's so messy talking in circles. I mean, I kind of get what she's saying, but I think they both have a point. This is something I would have to go back and actually look at the series of events a little bit more in detail because I missed this part of it, and kind of see who has a point there. But I think she makes some good points in this opposition. Brock says, just dropping in to show some love. Got to get back to work. Go do your thing, Brock. I appreciate you, man. Wood Drummer says, what you think about that guy saying Diddy paid him to Tupac? We're going to talk about it. We'll probably talk about it on Monday. Lauren says she capitalized footnotes, if I remember. She sounded mad to me. She sure did. Yeah, she sure did. And she emphasized some of the notes in here too. And in here, and in here. All right, let's go ahead and get to this next one because we've got a few of them to get to. So this one, let's see. This is the state's response in opposition to defendant's motion for correct ruling on adoptive admissions. Okay, so we're going to see something here. I want to look and see what all these are about. We've got the state's response in opposition to defendant's motion for correct ruling on self-serving hearsay. And then it's the state's response to defendant's motion in opposition for correct ruling on vague questions. We're really going through all of this. Come on, man. This is crazy. So these, again, all these are pretty quick. They're just 5 pages, and 7 pages. Let me see what y'all are saying in the chat. Let me see if anyone wanted to call into. I mentioned to y'all earlier, if you want to call into the show, you want to give your thoughts, you want to share your thoughts on anything that's going on. It just doesn't have to be this case. If you got smoke for me, if you got smoke for somebody who is in the chat, if you just have something you want to say in general, y'all can call in. I love interacting and having conversations with y'all throughout the show. So feel free to do that at any time and I will bring y'all up here. Let's zoom in a little bit because as y'all know, I cannot see. And we're going to keep it moving. That is not what I wanted to do. That is not what I wanted to do. Amy says, just water, no smoke. Yeah, we're not smoking like that. Boom, I got it. So we're going to go ahead and get into this one. All right, so it's looking like we've got another response from the state here when it comes to some of the issues that Brian Steele, aka Young Thug, Jeffrey Williams, were having in this case and throughout this case so far. So we're going to go ahead and get right into it. State of Georgia, Young Thug, aka Jeffrey Williams. And this is a letter to Judge Whitaker. All right, y'all check it out. The state's response in opposition to defendant's motion for correct ruling on adoptive admissions. Let's see what the background is talking about. All right. Despite binding Georgia and persuasive federal precedent authorizing their admission on July 10th, 2024, defendant Young Thug moved this court to vacate correct prior rulings on the introduction of adoptive admissions, under 24-801. Young Thug does not request specific relief on this matter, nor does Williams delineate why this court should eschew binding and persuasive statutory. Okay, we got a lot of big words up in here. We're just going to keep it moving for the regular people like myself. Nonetheless, trial court has correctly ruled on adoptive admissions in this trial in according to Georgia federal rules of evidence. Okay, so we're going to take a quick break right here and we got to figure out what's going on because I don't want to go through this whole thing and read it and pretend like I know what adoptive admissions are. So give me 1 second, y'all. We're going to figure this out in real time. Here we go. Adoptive admissions occur when a person implicitly agrees with or adopts a statement made by someone else. often through their actions or failure to deny the statement when it would be reasonable to do so. This concept is used in legal setting to suggest that the person's silence or behavior indicates their acceptance of the statement as true. Interesting. For example, if someone accuses you of wrongdoing in your presence and you do not respond or deny it, your silence might be considered adoptive admission. So essentially, it's someone saying, if you say nothing, then you essentially could be admitting guilt. Wow. What? Okay, so the state is basically saying that this is their response to opposition to defendant's motion for a correct ruling on adoptive admissions. Okay, so now this is making a little bit more sense. We're going to get into it. So, sending Georgia's former ban to their introduction to oblivion, the Supreme Court of Georgia, in accord with federal precedent, approved the introduction of adoptive admission in criminal cases in state versus Orr. The state's briefing argument and this court's order on the introduction of gang lyrics evidence the concept and application of adoptive admission were delineated in considerable detail. Well, what was the detail? Chief Judge Glanville order granting admission of evidence of lyrics at trial November 27, 2023 at page 27, subparagraph M states second supplemental motion in Lamine to admit evidence of the lyrical trial. Okay, so I thought they were going to give some explanation, but they didn't. Thanks for nothing, state. The state incorporates that material by reference and provides the following in summary and supplemental response. Rule 801 authorizes the previous court's ruling on the introduction of adoptive admissions and governs a trial court's consideration of the same. I hope they give some examples going out through this. Let's skip ahead a little bit in this because I want to see some of the examples here. So we'll go. Here we go. Young Thug is partially correct in asserting that mere silence by a party. Okay, so they explain what we just looked up the definition for. Young Thug is partially correct in asserting that mere silence by a party opponent in the presence of another statement standalone does not automatically equate to an adoptive admission. However, a defendant's silence may in certain circumstances communicate that he has adopted another person's statement as true. Make that statement admissible under Rule 801. I feel like I was just talking about this type of thing. Oh, man. That is crazy. So basically, if you're talking to your kids and you're going through and you're trying to figure out who took cookies out of the cookie jar, and I say, hey, what were you doing earlier? Oh, I was in the kitchen. Okay, and what were you doing in the kitchen? Were you get some food? You get something to eat? Yeah, I was getting something to eat. Were you near the cookie jar? I mean, yeah, maybe. I might have been, possibly. Did you open the cookie jar? I mean, is that what we're saying? Adoptive admissions are? I mean, if you're a little bit quiet after I ask you, you were in the kitchen, you might have opened the cookie jar. And then I ask you, did you take cookies out of the cookie jar? I mean, and you quiet? I don't know. Some of the attorneys, all the attorneys in the building who are watching, let me know if that is a correct assessment of what adoptive admissions are. And we'll keep it moving. I could be way off, but that's just how I'm reading it. I'm just a regular guy reading some documents, all right? In evaluating whether evidence qualifies as a defendant's adoptive admission under Rule 801, the trial court must find that two criteria are met. Here we go. You got to admit you were in the kitchen and you got to admit that you were near the cookie jar, is what I'm guessing they're going to say. I haven't read this yet. We'll see. The statement was such that under the circumstances, an innocent defendant would normally be inducted to respond, there are sufficient foundation facts from which the jury could infer that the defendant heard, understood, and acquiesced in the statement. After the initial determination is made by the trial court, the jury is then responsible for making the ultimate determination of whether the defendant adopted the statements as true. I think we're on the right track here, y'all. We're breaking it down. Are we becoming lawyers in real time? I think we're breaking it down. So I say, hey, I saw the light was on in the kitchen. You were in the kitchen. Is that correct? Yeah, I was in the kitchen. You know, there's a cookie jar in the kitchen, right? Mm-hmm. Why were you in the kitchen? I mean, I was a little bit hungry. Okay, well, did you get something to eat in the kitchen? Yes, I got something to eat. What'd you eat? Oh, I don't know. I got something out of the fridge, some oranges, or I don't know. Okay, well, what about cookies? Were you hungry for cookies? Did you want to eat some of the cookies in the cookie jar? I mean, maybe. Were you near the cookie jar? Did you open the lid? I probably could have. So you're telling me that you went into the kitchen, you were hungry, you saw the cookie jar, you opened the lid to the cookie jar. Maybe, who knows? You sat there, you took a whiff of the cookies, you were looking in there, and you're going to tell me that you didn't eat any of the cookies in the cookie jar. Now, the jury sees that, and then I say, no further questions, Your Honor. What are they going to think? They're going to think you ate some cookies. So I don't know, man. I could be totally off. I hope we have tons of attorneys that are tapped into the community and watch the show. Y'all let me know in the comments of this video. Am I way off or am I pretty close? A clear example was found in Wilkins, where the court found it reasonable that a statement referring to a bloody shirt in the trunk of the car that appellate drove up in was standing next to as the shirt. Wait, what? Hold on a second. We got to read this again. A clear example was found in blank, where the court found it was reasonable that a statement referring to a bloody shirt in the trunk of the car that appellate drove up in was standing next to as the shirt. We used to wipe blood and fingerprints off of a gun is the kind of statement that would normally prompt an innocent person to clarify that was part of the... Okay, it's not me. There's a ton of typos in here. It's an innocent person to clarify that the was not part of the we. We'll keep it moving. The foregoing said a direct confrontation with the accusatory statement is not always coupled with a lack of denial required for the application of Rule 801. I want to read this Rule 801 too. See, for example, the cases below. This case, holding trial court did not abuse its discretion by admitting statements in a rap video the defendant silently appeared in as an... The defendant silently appeared in as an adoptive admission. Like, who, Lord, somebody proofread this. I know we got a paralegal that can proofread this state. Y'all are tripping. Hold no abuse of discretion by the trial court in finding defendant's pre-arrest silence was an adoptive admission when defendant stood silent after being verbally accused of having intercourse with a minor. Hey, yo. Hey, run for your life. Holding statements were properly admitted as adoptive admissions when defendants remained silent in the presence of co-defendants, discussion implicating them all in illegal smuggling activity. Okay, so I think we're on the right track, y'all. If what I'm seeing from these cases below are right. So if someone says something and you're silent, the state is saying that you should be able to admit that as adoptive admission. Very interesting. We learned something today. I had never heard of adoptive admission, or I'd never heard it phrased that way before, but That's what we're here to do. We're here to learn, and now we know a little bit more of what it means. In conclusion, the trial court's prior evidentiary rulings on adoptive admission have been in accord with Rule 801D, 2 and B, and case law of the same. Adoptive admissions may be admitted in Georgia criminal trials. Young Thug's motion should be denied. And this also makes me want to find the original motion from Young Thug on this one, because I want to see what Brian Steele is saying the reason that these should not be admitted. So y'all let me know what you think in the comments. Did we give a good assessment? Did y'all learn something today about adoptive admissions? And what do you think that Judge Whitaker is going to do in this one? Let me see what the oh man, let me see what the chat is saying on this one. Amy said this analogy is hilarious. What about the bacon? Did you see bacon in there? Was there bacon in the fridge when you went into the kitchen? I counted all the cookies last night. There were 12 cookies in there. This morning there are 8. Why do you think those cookies are missing? Amy says, I bet ClassE has stolen cookies before. That is true. I steal cookies from my kids. If they got candy or cookies and they're not looking, I'll be snatching their cookies. And they say, hey, what else does Amy say? Adoptive admissions rule is a principle of evidence law that a statement that is against an accused is not admissible hearsay if the accused is aware of the statement and has indicated acceptance that the statement is true. The adoptive admission may be oral or written or by conduct. Dag tax. Ooh, I like this. I'm learning so many new terms today. Dad tax? Hell yeah. Yo, Wood Drummer is my hero. We got dad tax now. Woo, I'm about to go crazy. Halloween is good. They're going to be in shambles on Halloween. Dad tax? That is the best comment I've ever seen on this channel. Wow. You need a Sim said, just a bunch of words saying nothing. You ain't lying. Roro says, good job, ClassE. We're learning in real time, y'all. Nothing wrong with that. What else are y'all saying in the chat? Lauren Robinson says, graduates of ClassE Beats. Yeah, I'm not an attorney, so y'all don't take anything I'm saying too seriously. Do your own research. Tracy said, so basically throw yourself under a bus. Yeah, don't be doing that. No sharing cookies. Hey, yo. Oh, man. Everybody wants Amy to call in. Amy, call in. What are you doing? If y'all want to call in, the link to call in is in the description as well as in the pinned comment in the chat. Amy wants to call in and talk about stealing cookies. We got Jenny D is in the building too. Wood Drummer just made my entire life. Dad tax. I'm good. We got to put that on a t-shirt. That is amazing. Absolutely amazing, man. Let's go ahead and get into these next couple motions. I'm gonna wait and see what y'all are saying in the chat, and then we'll move on real quick. Mixed Chick Samantha said Amy's eating cookies. Amy is not sharing her cookies. I guarantee. Amy is keeping all those cookies to herself. Roro says Judge Whitaker is fair. That being said, and lawfully, she should grant bond. I think so. I'm with you. Wood Drummer said, glad I could make you laugh. That is amazing, man. That made my day. Lauren Robinson said at Halloween, he gonna be snatching Reese's. He's talking about dag tax. I'm gonna get him. And he said, nope, I'm eating pineapple. Get him. I'm gonna be taking all those kids' candy. Dad tax, that is just, That is amazing. Thank you for that, Wood Drummer. We are definitely going to be using that. Amy says she'll share some water. Here's to the water game. Let's keep it moving. All right, y'all ready for this next one? We got a couple more. Y'all want to take a break from these motions? The motions are cool, but I did have one other thing I wanted to get to. And this one is from Mr. Weinstein as well. So I think this will be a good break from getting into these motions, because we've got, let's see, so that we've got that one. We've got two more. We should be able to get into this.
I just threw a quick Google search.
Do. And so we have to presume that the judge.
All right, let me rewind this so I can cue this video up from y'all. And I got to take it off of chipmunk mode. We'll get a couple more comments and then we'll get into it. Mixed Chick Samantha said mom tax is way better. And I don't know. That dad tax is looking pretty nice right now. Mr. Tesla's up in here, says, no lie, I just got some lemon cookies from Walmart. Hey, let's go. Shout out to the Walmart lemon cookies. Whew. Best in the game. Lauren Robinson said Weinstein stood on business. His footnote was awesome in his motion. Yeah. Yeah, he absolutely killed it. I love everything about that motion. Probably going to be one of my favorite ones for sure. Amy says, I prefer to call it the daddy tax. Oh, man.
What did he say?
Y'all know what's up. Okay, we're going to go ahead and get into this one. We won't take a comfort break. We're going to keep it moving. All right, so a lot of y'all know recently we had the state is trying to silence so many of these attorneys, the defense attorneys specifically in this YSL trial. And the attorneys, the defense said, no, we're not going to be silent. We're going to keep moving. If y'all want to try and silence us, then you need to look in house and see where you've already broken your own rules and the rules that you're trying to hold us to. So not long after, and actually the same day that the state filed this motion, Mr. Weinstein, Doug Weinstein, Yak Gottit's attorney, went on to an interview and started talking again. This man is a savage. He was not holding back. He didn't care. He said, no, I have rights. Y'all cannot tell me I can't go out here and talk about this trial that I'm actively involved in, and that's being broadcasted to the world. So here's what he had to say in this interview with Megan Cuniff. Hopefully I said her name right.
Doug, thank you so much for joining us this afternoon. I did see your response on Twitter a few minutes ago where, you said that you have a duty to represent your client who's a public figure and that he's been smeared by prosecutors. And is that, can we expect to see an argument like that in a filing that responds to this gag order request? Is that?
Yeah, now keep in mind, this was actually before we found out that he responded. So we're going back in time a little bit.
At the defense here?
Yeah, and just to be clear, I don't think I used the word smeared by the prosecutors, but I think I said that his reputation has been tarnished by the state. Just, I don't know if that makes a huge difference, but
probably
first
not.
off, I should start by telling ADA Love and Hilton hello. How are you guys doing? So I guess
oh, this guy. These defense attorneys are amazing, man. Can we get a round of applause for these defense attorneys? They do not care. I don't know. I didn't see this type of attitude from them. Well, you can kind of say it with Brian Steele, but before, it's interesting to see how the scales have tipped when it comes to the confidence and attitude of these attorneys. I think if you guys look at some of the ways each side is talking right now, who is clearly in favor. I mean, you've got the defense. They got a new judge. They got Judge Glanville up out of there. They've got the backing of the Supreme Court. The Supreme Court is watching this now, the Georgia Supreme Court, because Brian Steele said, hey, y'all, this man, he's trying to lock me up in prison for 20 weeks. Can we do something about this? They say, yeah, we got you. Also, Glanville, you're not going to rule on these recusals. So the defense is feeling good right now. And now that they've got their judge in there, Judge Whitaker, who they helped, the defense helped run her campaign, her reelection campaign. I mean, they are on cloud nine, and you can hear it. It's absolutely hilarious. I'm loving it, man.
By the state. Just, I don't know if that makes a huge difference, but
Shout
first
out to
off, I
Doug
should start
Weinstein.
by telling ADA Love and Hilton hello. How are you guys doing?
Dang.
So I guess y'all are watching me now, and maybe have always been.
They're watching this live stream right now.
So how are we going to respond? Well, it's pretty simple. Just look at the rule that the state cited in their motion, Rule 3.6. And I'm permitted under that to comment on information that is in the public domain.
That's correct.
And so my comments have been limited to those things that have been filed publicly, that have taken place in the courtroom. It's unlike, maybe not as the state wishes, but this is a public trial. The witnesses, all the proceedings have been streamed out to the public. The courtroom has been open. I know that the state has repeatedly wished that some of the witnesses not be put on video. And for the most part, they've gotten their way on that. But I think this is just part of the pattern of the state not wanting the public to see what's happening in there. And yeah, I have the absolute right and obligation to speak out. My client's a public figure. He has a career as a singer, as an artist, as a writer. And I have a duty to him to not only advocate for him in the classroom, but to advocate for him in the public arena.
And it seems like their reading of the Georgia rules of professional conduct. I mean, when I'm reading this, I'm like, does their interpretation of this allow for any public comment whatsoever? The comments that they cited seem to be criticisms of them and then proclamations from the defense that their clients are innocent. But that seems to be stuff that we hear about in cases in high.
Yeah, and that's a great question by Megan, because they're basically saying, as we said in past videos and live streams, that they didn't like their feelings being hurt. They said they're talking about us. They're making us look bad. They're getting on all these live streams. People love them. Where's our YouTube channel? Who can we go talk to? And you've got even people, I'm not going to name names, that have worked for the district attorney's office that are like, I really don't want to talk to them when it comes to the prosecution and ADA Love and Hilton. So they're kind of out on the island right now. And the defense has a huge plus in the court of public opinion. And that's just a fact.
High profile cases.
Yeah, and we're absolutely under Rule 3.6 allowed to do that. And it wouldn't be the first time that they have put forth an argument that I believe doesn't have merit. So
hey, he's taking more shots.
I'm happy to file a response and swat this away. But unless, of course, I'll do whatever the court orders. Let me make that clear.
Yeah.
But I don't believe that a court, this court, or any court, would rule in their favor on this, or will rule in their favor. So I don't anticipate being gagged in any way by this judge. I mean, I was looking back in Georgia, like there was a gag order in the Ahmaud Arbery case, but that was a very different situation, if you remember, Megan.
I didn't know that.
I mean, did you look at that gag order?
No, I haven't seen the gag order. I'm familiar with the basics of that case, but what do you see as the big differences that led to the gag order there?
Sure. In that case, that was an order that took place before the trial commenced. So you
not
had
because someone got their feelings
potential
hurt.
Jurors that were out there that could be seeing the statements. And in this case, our jury is impaneled. And they are under a directive from the judge to not consume any information about this case, to not talk about this case. And Chief Judge Glanville always did a great job at the end of, I think, every day, giving the jury, and you guys have seen it, he gives the jury the directives on what they're allowed to do, what they're not allowed to do.
That's a good
and
point.
So we have to presume that the jurors are following the instructions of the judge. So they shouldn't be consuming any of this in any way. So I don't think any statements I make are prejudicing this trial at all. All I'm doing is educating the public on what's happening in that courtroom.
Yeah, and he makes such a great point. All that's happening right now, we're seeing in real time. So the attitude we talked about, ADA Love shaking her head. Y'all even mentioned, which I didn't really see a big issue with, but a lot of y'all mentioned in the comments her walking away while the judge was talking to her, being rude. And then you're seeing Brian Steele go back and forth. The breaks, the comfort breaks that Judge Glanville's taking. We're seeing all of this. So you saying that Mr. Weinstein can't go onto a YouTube live stream or can't do an interview and say, yeah, you know, when Judge Glanville was attacking Brian Steele's character by saying that he was unprofessional and that he was unprepared, I took offense to that as an attorney as well, because I could see how that can not only affect how he's seen by the public because he's broadcasting, but I took offense to that because it affects his client and affects his ability to do his job. And that wasn't right. And Judge Glanville shouldn't have been able to do that. I mean, what's wrong with him saying that? That's freedom of speech. He was there. We got to see it in real time. So this is all just a game by the state.
Right. I did see just through a quick Google search that there was a gag order issued in the RICO case involving the Cop City protesters. Is that do you see differences between that case and this case, or just what they're doing, or were they weren't like 19 months into trial when that gag order was issued?
Yeah, and I haven't seen that gag order. I mean, obviously, I'm Suri Chada Jimenez is a colleague of mine, and I believe he's under that gag order. And I haven't been following Cop City that much, but I do know they haven't gone to trial yet. So I haven't read the order, but that's a major difference, because that's a situation, again, like Ahmaud Arbery, where you've got potential jurors that would be out there consuming media. Our jurors are not doing that. They're instructed not to do that. They've been impaneled. No, they're not sequestered, but they are under instructions to not look at any of this.
Yeah, and I want to put a public service announcement out there for any content creator that's watching this. Hey, y'all better enjoy this while this lasts, because I can guarantee you that judges, the district attorneys moving forward, they are going to point to this case and the precedent that was set here and say all these interviews, Caleb Bumpus, Doug Weinstein, Max Sharp, all these guys out here doing interviews and saying, Judge, before this trial starts, can we get a gag order in place? Because this is such a high profile case and there's a lot going on, that these attorneys can't be out here talking and doing interviews. So moving forward, I wouldn't be surprised if we saw more of these in place, especially with these type of big cases. But it's still fun for us to see, and I love and enjoying it, man. So enjoy it while it lasts, y'all, because it's not gonna be here for long. Let me know what y'all think in the comments. Did Doug Weinstein make the right move here? Is this a smart move by him to push back? I know he just filed his response to this. Y'all can go and watch that in the next video if you want to see what his response was to the state saying they don't want him talking anymore. And you can actually see where we break down the full document. Let me know in the comments what y'all think about this one. And I'm going to go to the chat and see what y'all are saying too. Amy agrees with me. She said this case will be used as an example. 1000%. And if I'm a district attorney in any county, I'm saying, man, if we get a big case like this, we need to make sure these dudes aren't out here talking about it, because the court of public opinion is killing Fulton County District Attorney's Office right now, me included. Roro says, mixed chick, I know, right? But when Woody said, get back, and she ran too. Oh, I gotta find that video. That was tough. That was tough. Mixed Chick Samantha says, I was dying when Biden told Love, I don't want your apology, after she said sorry. Or Brian said that. Dang, I must have missed that. What else are y'all saying in here? Mixed Chick Samantha says, I believe Thug's dad asked for there to be no cameras. The court said, nope. Yep, they did this to themselves. It's on AV's video. Okay, shout out to AV to the 7th power. Y'all go check her out. I'll definitely have to see if I could find it. Lauren also says, but this is why all high profile cases should be televised, because this has been wild from the start. But the last 2 months, man, you are 1000% correct. Jenny D says, I can't wait to see Love be put in her place if she tries the stuff she was doing with Glanny. Not to mention, she might not even be here for long. We talked about it. Brian made sure to, one of the first things he did when Judge Whitaker was brought in, he made sure to say, hey, we got to get these two out of here as well, because they're a problem. We'll see. El Papacito says, the Honorable Attorney Weinstein took a page out of the Honorable Brian Steele's playbook and taking it to the state. The defense for the state on their heels. Absolutely, man. Absolutely. They're hurting right now. They are hurting, man. It's wild out here. Amy's got a TikTok video for us. What is this that Amy sent in? Oh, this is where Lil Woody said, get back. He said, ooh.
For Echo Hotel, and once again, Echo. Get back.
Look at his face. And then he looked at her like she did something to him. He was like, that's tough,
For
man.
Echo Hotel, and once again, Echo. Get back.
He said, what you got going on? Dang, that's tough. That is tough. Shout out to Lil Woody. Let me see. Let's get a couple more. We might have, I know we had some more of these responses from the state that we needed to get into. Let me find a good one. This is the motion for correct ruling on self-serving hearsay. And this one is the motion in opposition for correct ruling on vague questions. I'm going to ask y'all which one you want to go through. Y'all tell me in the chat, which one do you want? Do you want correct ruling for self-serving hearsay, or do you want the ruling on vague questions? And I actually had a couple more. Oh, one thing I was going to go over, I was going to review what they were talking about with the Cop City gag order trial, but I'm going to leave it alone for now. We also had, yeah, we'll leave that alone. Let me see what y'all are saying in the chat. Amy says vague question. Okay. Gigi says she had on too much perfume. Yeah, a lot of people are allergic or sensitive to perfume and cologne. Mixed Chick Samantha said, what he said, no to the water. That ain't alkaline. You know, we got to take a drink on that one. Y'all get your alkaline water up in here. He said, get back. Get back. Snap and Slap is in the building. He said, I'll take, can I go home for 500? Yeah, I'm with you on that one. Oh, man. Okay, so Amy was the only one that answered the question. So we're going to go with what Amy said. She said she wants to go with vague questions. So we're probably going to learn something here too. Because again, I'm not as familiar with this game. But classy the way he said, get back, get back, get back. You stink. Oh man. Let's go ahead and get into it, y'all. So we have another response from the state going in on these vague questions that Brian Steele, aka Jeffrey Williams, aka Young Thug, had an issue with. We're going to go ahead and get right into it and see what the state is saying in their response to this. We got the state of Georgia versus Young Thug, aka Jeffrey Williams. And this is a letter to Judge Whitaker. State's response to defendant's motion in opposition for correct ruling on vague questions. Here's the introduction. On June 10th, Young Thug moved this court to vacate correct or proper rulings on the state objections precluding cross-examination with vague questions. What is the note? On July 10th, defendant Young Thug filed an amended motion. Defendant Young Thug's motion addresses multiple separate evidentiary rulings. The motion addresses paragraphs 10 regarding state objections to vague questions. All right. Williams, or Young Thug, does not include a request specific relief or provide authority to substantiate his request. Instead, Williams cryptically asserts that somehow his right to effective cross-examination has been curtailed. The trial court correctly sustained the state's objections to Young Thug's vague questions and has not impeded Young Thug's right to cross-examination. Young Thug's motion should be denied. Argument and citation of authority. At the outset, Young Thug never provides authority that inquiring into vagaries. What? Oh, I'm definitely using that word. Have y'all heard this word before? Vagaries. I'm going to start telling people, stop using vagaries. At the outset, Young Thug never provides authority that inquiry into vagaries classifies as a specific mode of cross-examination imparted by constitutional requirement. See Johnson versus State. Unlike many other modes of impeachment, attacks on witness bias are constitutionally guaranteed. Even grounds that can we get the district attorney's office just one paralegal? What are we doing? Even grounds that are continuously protected, however, may be subject to judicial controls. Lucas versus State, the right to inquire into partiality and bias, however, it's not without limits. The Fifth Circuit has made it clear that ambiguous questions are not constitutionally protected and subject to exclusion by trial courts pursuant of the rules of evidence. I don't know about this one now. This one seems a little bit wild. The court should exercise reasonable control over the mode and order of examining witnesses and presenting evidence so as to make those procedures effective to determine the truth, avoid wasting time, and protect witnesses from harassment and undue embarrassment. The rule permits courts to preclude questions that obscure truth because they are ambiguous, confusing, misleading, argumentative, compound, or assume facts not in evidence. I mean, so that sounds like a vagary to me. I love that word. Young Thug's motion attempts to constitutionalize an areas of cross-examination that is not so protected. So they're saying there's a gray area, even assuming, okay, we read this in the last one, so we're going to move forward. Young Thug's Sixth Amendment right to effective cross-examination is not infringed by disallowing vague questions. The court has correctly sustained state's objections to defendant Young Thug's vague questions because such questions are impediment to ascertain of the truth. Holds to that jury proceedings shall be conducted to the extent practicable so as to prevent inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof of asking questions in the hearing of the jury. Okay, and then they cite here, we can see Carlson and Carlson. We won't look at that. Courts are, moreover, mandated to exercise reasonable control over the mode and order of interrogating witnesses and presenting of evidence in order to make interrogation and presentation effective for the ascertainment of the truth. Defendant Young Thug argues that the court's sustainment of objections for vague questions have curtailed defendant Young Thug's Sixth Amendment constitutional rights, but cites no legal authority for that proposition. I mean, I guess the only authority he needs is that he should be able to ask the question. Is that what they're saying? He argues that the court's sustainment of objections for vague questions have curtailed. We'll keep reading. Case law explains that the Sixth Amendment provides two types of protections for a criminal defendant: the right physically to face those who testify against him, and the right to conduct cross-examination. State v. Burns. However, the Confrontation Clause guarantees an opportunity for effective cross-examination, not cross-examination that is effective in whatever way and to whatever extent the defense might wish. All right, let's skip ahead a little bit. Vague questions are improper. Defendant Williams' Young Thug's assertion that this court has incorrectly sustained objections to vague questions is incorrect. The 11th Circuit had held that a question or phrase is ambiguous as a matter of law when it is not a phrase with a meaning about which men of ordinary intelligence could agree. Okay. I mean, saying this, I don't know. Who determines that though? I guess the judge does. Nor one which can be used with mutual understanding by a questioner and answerer, unless if were defined at the time it was sought and offered as testimony. Ambiguous, i.e. vague questions, are impediment, to the assertion of the truth, because such questions left undefined by the questioner prohibit mutual understanding to the meaning behind any answer by the witness. Repetitively proposed vague questions by Young Thug's voice cluttered confusion on the jury. We're learning a lot of new words today. Whereas unambiguous proper questions provide the jury with concise clarity of the facts and better equips them to ascertain the truth. Okay, so we're going to go through there. That's fine. We're going to go through the conclusion at the end here in a second. Let's just read this last paragraph. The prior objections the state has lodged and inadequately phrased vague questions asked of the witness by defendant Young Thug have been correctly sustained by this court to facilitate ascertainment of the truth. For example, Young Thug asked Atlanta Police Department Detective Belknap, "Do you know there are videos of countless performers or athletes where they are promoting their trade?" The state objected to this question because it was vague. That's a vague question. So should he have asked, "Hey, have you ever seen Sierra or other artists perform?" How is this a vague question? He asked, "Do you know there are videos of countless performers or athletes where they are promoting their trade?" Okay. The state objected to this question because it was vague. They are being petty, man. Come on. The question was ambiguous because it is unclear what videos, which performers, and what trade the question referenced. Okay, I could possibly see the trade. Because if we're going to talk about WAP by Cardi B and Meg Thee Stallion, then I mean, maybe you might be wondering what the trade is there. I'm going to leave that one alone. So maybe I'll give them half a point on this one. But I mean, come on. If you're an athlete or a performer, your trade is performing or being an athlete. It's not that complicated or vague. Wow. Court properly sustained this objection. Oh, shout out to Glanville. Of course it was proper. On the grounds under its inerrant authority under 24-6-611. Young Thug's assertion that his Sixth Amendment right have been curtailed by the court's sustain of the state's objections to vague questions is invalid and unsustainable. There is no constitutional or statutory right to ask irrelevant, vague, and ambiguous questions during cross-examination. This court's prior evidentiary rulings on this matter have been in accord with the Georgia and federal constitution and rules of evidence. Young Thug's motion should therefore be denied Adrian Love. I hit the wrong sound effect. So y'all let me know what you think in the comments and in the chat. Is this petty? Does the state have a point? Does Brian Steele need to back off? I'm gonna let it go at this point. It's up to y'all. Let me see what y'all are saying in the comments too. Shout out to the comment gang over there. This whole trial has been absolutely wild. We might get this. What time is it? I think we got to get out of here. We'll get this last one probably on Monday. Yeah, that was an accident, man. I did not mean to hit that boo. Amy said, he said, "WAP." I'm just saying. He talked about, what did he talk about? Promoting their trade. What kind of trade is WAP promoting? Need a bucket in the mop. Oh my God. Lauren Robinson says, fighting for her life, trying to write motions and update the resume simultaneously. God dang. That's tough. Snapper Slapper says the ambiguous duo. They are, yeah, we got a lot of pots calling the kettle black over here. Amy says that was a broad question. This is petty. I agree. Why Thugger just dropped a video called Letter to Glanville? Oh Lord, are you serious? Stop playing. Stop playing. There is no way. Now y'all got me wanting to look this up. Let me see. Amy says, Woody covered his face and said, "Get back." He said he smelled something. He was not feeling it. Not feeling it at all. Here we go. Vagaries are unexpected and unpredictable changes in a situation or in someone's behavior that you have no control over. Interesting. Vagaries. All right. There we go. There's the definition. Y'all better stop playing. Letter to Glanville, Young Thug. Are you playing Mixed Chick Samantha? Is that a real thing? Where did he drop it on IG? Where is it? Now I gotta go to X and see if I can find it. Hold on. This will be our last thing. That would be crazy. Hold on. Letter to Glanville.
How did you come upon this information? Who told you?
She's not lying.
Is why wasn't I there?
Trick this man with a plan with immunity that forced him on the stand. I object on how you trying to do this, man. Lil Woody wanted to plead the fifth and now you trying to force his hand.
That's not Thug. That's not Young Thug. That's not Young Thug, but this is funny. I'm gonna have to listen to this. Hey, shout out to whoever made this. Oh man, that's crazy. People are funny. All right, shout out to Mixed Chick Samantha for letting me know that, and shout out to Thugger Daily for dropping that too. What else are y'all saying? El Papacito says the state filing these baseless motions are frivolous, and the court should deny and sanction them for wasting the court's time. Well, you know, they said they had to and they were going to respond, so I guess this is them keeping their word. But yeah, a lot of this is just, it seems very petty. Anyway, y'all know what time it is. Tonight, 8 p.m. Eastern Standard Time. Y'all make sure you stop by and check out Song of the Night Live. We're going to be hearing some dope music. We are going to be giving away $100 in cash and a brand new Shure 55SH microphone. We're also giving away 2 spots in next week's Versus Challenge and 4 door prizes. So even if you just enjoy listening to music, it's a good time to hear some new up and coming independent artists. Have a good time and enjoying the show. And it's going to be a lot of fun. So I'm looking forward to seeing y'all there. Hope y'all have a great rest of your day. Shout out to Mark in Texas for the subscribe. Appreciate you, man. And y'all have a great weekend as well if I don't see you tonight. We're going to be dropping videos throughout the weekend too. So we've got another video dropping this afternoon. Y'all definitely want to make sure you tune in for that. And we've got 2 videos dropping on Saturday. We might even have 2 or 3 dropping on Sunday. So make sure, if y'all haven't yet, make sure you subscribe, hit the notification bell so you don't miss any time we go live or drop a new video. I appreciate y'all. Y'all have a great rest of your day. And of course, you know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace.
We're real strong people. We can do anything. We can't be worried about what they say. My brother, my sister, just believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself. Believe in your skin. Believe in your health. Believe in yourself. Believe in your talk. Believe in your walk. Believe in yourself.
Since everything starts with self, let me hold this mirror up and take a look at myself. Before I judge you, I gotta check myself. And I come to find out that that's good for my health, right? Change your mind and watch the whole body follow. So you won't hear me talking about I'm hitting you with hollows. I can't do it, got plans for tomorrow. And I ain't trying to bring my seeds no type of sorrow. Wait, cause fake rappers do fake-ish. I mean, most the basic get replaced quick. I'll never sacrifice my truth is, so I might never get a million records sold. But that's cool, cause I'm good with the creator. He nurtured my thoughts, so I present you with verbal flavor. You never listen to what no haters say. We pray for them, but we gon' move it this way. We moving forward, y'all.